Senator Adam Schiff pressed a Trump judicial nominee with a question that sounded simple, but quickly exposed a deeper contradiction. If a judge can publicly weigh in on controversies involving universities and hiring decisions, why can't that same judge answer basic questions about January 6th or the outcome of the 2020 election? What followed was less about politics and more about whether the standards judges claim to follow are being applied consistently.
Mr. Chairman, Mr. Traynor, I just want to follow up on my colleague's questions and make sure that I understand this. You were asked a series of questions about January 6th, and correct me if I'm wrong because I was not here at the time you were asked those questions, and you declined to go into whether this was an insurrection, the nature of the attack on the Capitol, because you said it might involve a case or controversy that would come before you. Is that correct?
Senator, it did involve cases or controversies. We had people in the District of North Dakota that I believe were charged.
So you felt it wouldn't be appropriate for you here today to discuss your views on what took place on January 6th, is that right?
I stated that what I saw was deeply troubling, Senator. The attacks on law enforcement, any attack on law enforcement should be condemned.
So why are you reluctant to answer questions about what took place on January 6th? On the one hand, and on the other hand, you say judges don't forfeit their First Amendment rights. You feel free to write to a university to tell them who they should hire or not hire, who you're going to hire or not hire. You feel free to immerse yourself in that controversy. But here you won't talk about your views of January 6th. Can you reconcile that for me?
Yes, the difference, Senator, is that there is no case or controversy with regard to hiring of law clerks, but handling matters
well,
that come...
you're saying there's no case or controversy involving Columbia, involving the efforts by the administration to punish Columbia, all the litigation around Columbia, that wasn't the case or controversy?
That was far afield from the letter that was signed, Senator.
Really? Why is it far afield? Weren't you complaining about what was taking place on the Columbia campus, and as a result that you weren't going to hire law clerks and the other judges on your letter weren't going to hire law clerks? Wasn't that the nature of your correspondence?
Yes, that was the nature of the correspondence.
So you feel perfectly free to immerse yourself in that, exercise your First Amendment rights there, but when it comes to asking you basic questions about January 6th, you won't answer those questions.
The difference, Senator, is that there are cases or controversies that I have before me as a district judge relating to individuals that have been charged for conduct that occurred on that date in this Capitol.
So does that mean that any litigation involving Columbia you're prepared to recuse yourself from?
Senator, the limitation on Columbia was in regard to hiring law clerks. I hold no bias against the institution itself.
Well, whether you hold a bias towards it or not, you're saying today that you can't discuss any of the January 6th stuff because there are pending cases or controversies, even though they've all been pardoned by the president. I'm not sure what case or controversy you're referring to, but nevertheless, you're unwilling to say you recuse yourself from a case or controversy involving Columbia when you specifically weighed in there. How do we reconcile that?
Well, Senator, as I stated in the recusal order that Ranking Member Durbin raised, I indicated that I held no particular bias against...
Well, yeah, that's fine. You can say you hold no particular bias about January 6th, too. I mean, it's easy to say. Your letter demonstrates a very clear bias. I'm not saying that it's an unreasonable bias, but it is a bias. It is a prejudice in favor of one view that would cause people to question your impartiality if that case came before you. That seems to me a stronger, much stronger case for recusal than the one you're making to refuse to answer questions about January 6th. So let me just ask to make sure that I understand the limits of what you're prepared to say. Who won the 2020 election?
Senator, as I indicated in response to questions from Senator Blumenthal, Justice Ketanji Brown Jackson, as a sitting circuit court judge at the time of her nomination, was asked this question in questions to the record.
I'm asking you the question.
Yes, and as a sitting judge, I will tell you that it is not appropriate for a judicial nominee to engage in discussion regarding a matter of political controversy with that.
See, this is completely inconsistent with your involvement in the whole Columbia controversy. Completely inconsistent. Because you involved yourself in that controversy. You went out of your way. Nobody asked you to write that letter. You took this upon yourself to do, to insert yourself into that. But you're saying here, you can't answer a simple question about who won the 2020 election because it would somehow implicate you in controversy. I'm sorry, there's no way to square those two things. Mr. Chairman, I yield back.
Okay. Now we go to Senator Whitehouse.
At first glance, this exchange appeared to be another familiar debate over the 2020 election. But Senator Adam Schiff was pursuing a much more specific argument. The nominee, Judge Daniel Traynor, had previously declined to offer detailed views about January 6th, explaining that cases connected to those events had come before him, and that judicial ethics required caution when discussing matters that could involve ongoing controversies. On its face, that's not an unusual position. Judges and judicial nominees are often reluctant to comment on issues that may later appear in their courtrooms. The principle is designed to preserve public confidence that cases will be decided based on evidence and law, rather than preconceived opinions. Schiff, however, argued that the nominee had not applied that principle consistently. He pointed to Judge Traynor's involvement in a public letter regarding Columbia University and law clerk hiring decisions. In that instance, Schiff noted, the nominee had exercised his First Amendment rights and voluntarily entered a politically charged public debate. According to Schiff, that raised an obvious question. If judges retain the freedom to publicly express opinions on some controversial subjects, why invoke judicial restraint only when asked about January 6th or the results of the 2020 election? That distinction became the heart of the hearing. The exchange highlighted a challenge that increasingly defines modern confirmation battles. Americans expect judges to be impartial. At the same time, they also expect honesty and consistency. When nominees choose to answer some controversial questions while declining others, lawmakers inevitably ask whether the standard being applied is rooted in ethics or convenience. The conversation also revealed an important truth about judicial confirmations themselves. These hearings are not simply examinations of legal competence. Senators are trying to assess temperament, judgment, independence, and credibility. How nominees explain their reasoning can matter just as much as the reasoning itself. Schiff's frustration centered on what he viewed as a contradiction. The nominee argued that discussing January 6th could affect perceptions of impartiality, because related matters had appeared before him. Yet Schiff suggested that publicly taking positions connected to Columbia University created its own appearance concerns, particularly if future disputes involving the institution reached the courts. Whether viewers agree with Schiff's criticism or Judge Traynor's defense, both sides touched on a legitimate concern. Judges occupy a unique position in American democracy. Unlike elected officials, they are expected to stand apart from political passions and apply the law fairly. But judges are also human beings with constitutional rights, personal views, and public voices. Where should the line be drawn? That question has become increasingly difficult to answer in an era when virtually every major national issue carries political implications. If nominees speak too freely, critics may question their impartiality. If they refuse to answer direct questions, critics may question their candor and independence. The exchange took another turn when Schiff asked who won the 2020 election. Rather than providing a direct answer, the nominee pointed to past confirmation practices and argued that judicial nominees should avoid engaging in matters of political controversy. Schiff saw that response as further evidence of selective restraint, particularly given the nominee's willingness to participate in other public controversies. Ultimately, this hearing was not just about January 6th or the 2020 election. It was about consistency. The Senate's constitutional responsibility of advice and consent depends on its ability to evaluate whether nominees apply principles evenly rather than selectively. For Schiff, the issue wasn't merely whether a judge remained silent, it was whether the reasons for that silence held up under scrutiny. And that's why this exchange resonated beyond the committee room. It raised a broader question that Americans continue to wrestle with. Should judicial impartiality require silence on contentious issues, or does true independence demand the courage to apply the same standards no matter how uncomfortable the questions may be?